Hey, yo, what's mobbin'? It's your boy Kid Nook, man. I ain't gonna lie, dawg. I need some answers, man. Y'all heard about Young Thug not getting no bond? Man, let's get to it.
Custody since the 9th day of May of 2022. This is in my motion. It should be in my motion. He has sat through unnecessary jury selection for months, bringing in over 2,000 people when the jurors were chosen from the first 511. That should not be on him. This is excess. He's now sat here for a month while the antics of Judge Glanville and Lawyer Love and Lawyer Hilton cause him to just wander and squalor in a jail. The case is, God forbid there's a conviction, going to be reversed potentially because these are serious issues, and I've raised them. I've put them to the court. There are issues of confrontation clause violations, prosecutorial misconduct, judicial misconduct, not being present at a critical stage of proceedings. There is no reason to believe that Mr. Williams is fleeing. He would be crazy, because if he flees, the case goes on because it's mid-trial, and he waives his appellate rights. He has the strong...
It's not a factual finding. It's substantively before me. And if that is the case, then there will be a different ruling made that will impact this trial, that may result in a mistrial, that may result in a mistrial with prejudice, but that would not impact a reconsideration of bond. Now, if there's a mistrial without prejudice, then bond maybe could be considered then. That might be a changed circumstance, but right now we don't have that.
And I'd like you to address just one last thing then. Judge and district attorneys come out after the ex parte hearing, and not a syllable about Brady evidence. It all should have been spilled right then. That's an ongoing concern.
What a lot of people don't understand with this whole thing is the judge isn't wrong in this aspect. I like this new judge for a lot of reasons, is that she goes by the book. So even though I know a lot of people don't want to hear that, she didn't give Jeffrey Williams a bond, the thing about it is she never said when she got on the bench that she was going to reconsider bond. They put in motions to reconsider based off of Glanville's standing, but she's never said that she was going to reconsider it. They put the motions in. So she's saying in order to get her to reconsider bond, there needs to be a change in whatever's going on with the client. There has to be some type of change that would change her mind to say, okay, these circumstances have changed. I'm going to give them a bond now. They were leaning towards the whole ex parte hearing to say, oh yeah, well, he was biased. But see, the thing is, with the way that the other judge wrote it down before it went to another judge, they basically said that Glanville didn't do anything wrong. They're just saying that he was wrong because it shouldn't have happened. But there was no bias in why he had the ex parte meeting. So them using that was not enough to get her to change her mind. And what I liked was she was saying that she wasn't just saying like, oh no, I'm not doing it, I don't want to hear this, like Glanville would. She was saying, well, I hear what you're saying and I understand what you're saying, but what you're telling me is not, what we use by law to consider a bond, to reconsider a bond. So with that being said, like I said, she goes by the rules, and I feel like she'll give Jeffrey Williams and the rest of the YSL members a fair trial. I've watched this thing live, and I tell you right now, she was going in on the prosecution way more than she was going on the defense. But of course, as usual, the blogs only want to pick up what she does when it comes to Jeffrey Williams to make it seem like this judge is biased as well. I've been watching this since day one. Glanville definitely was biased and had his own biases, whether the judges wanted to say that or go against him or not. He definitely had a bias. Was he getting better? Yes. But he definitely had some sort of bias. I like this new judge for a lot of reasons. She's doing everything by the book, and she's doing good so far. That's all I can say. If she says something or does something that's out the way, I'll be sure to, react to it. But I think that today with the motions and everything, she did a great job. She let everybody talk. She wasn't cutting people off. She wasn't rude. And she was by the book. And what I loved the most about everything was she called out DA Love for all of her antics. This is the second time that y'all have appeared before her in court, and she's already talking to you about candor. If you don't know what I'm talking about, this is the clip right here.
It was, I don't recall. That's what he said. I don't recall. Did you say this? I don't recall. I don't recall. So the state got in his prior statements to Detective Quinn. Well, I impeached him. He gave me a statement on recording. The state then doesn't ask Mr. Bean in front of the jury, doesn't ask him in front when he's here to be cross-examined. They come up with the Judge Glanville ex parte, give him some sort of document that supposedly shows Mr. Bean is scared, which I doubt. This is just me doubting, I have no evidence. And then in the middle of that document says that Brian Steele and his investigators, I'm not quoting, were in a car with Mr. Bean and his son. And Brian Steele was telling Mr. Bean what to say. And his son has that on recording. That never happened. That never happened. But what Miss Love was allowed to say in front of the jury, believe it or not, did Mr. Steele stop and start that recording? Mr. Bean said what he always says, I don't recall. I objected outrageous. Outrageous. It just flows right through. The same way Miss Love stands here today and says it's hard to hear, or whatever her words are, hard to decipher on an Apple iPhone. That did not happen. It is offensive. The legal analysis is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it, because she sat here in court and I did the same thing without being tempered.
All right.
That's 4 times.
Thank you for clarifying that.
Your Honor, may I briefly respond?
Yeah, when Mr. Steele clears the area. Yeah, go ahead, Ms. Love.
Thank you, Judge.
Do you have any Georgia law that represents what you have asserted in your motion and amended motion?
Your Honor, that's just it. I have been clear in my amended motion, and
Which
to the
I
extent
just
that it wasn't.
got a copy of.
Yes.
Okay.
And also, I just want to say that.
No Georgia law that.
Right. Georgia law does not define, it does not define case in chief. It does not break it down.
We all know what a case in chief is. Don't we? I think we all know what a case in chief is. Is there any support for your assertion that reciprocal discovery is required based on the concept of substantive evidence?
Your Honor, what I have said and what I maintain is that, one, there is an absence, and I'll point the court to 3 different cases, Harris versus the state, 314, Georgia 238 as one. And these are just instances.
238? What did you say?
Yes.
Okay. What are the other 2, and what are they going to represent?
307 Georgia 171, which is the 2019 Green case that Mr. Steele cited for the court, and 146 Georgia App 423, which is Phillips versus the state. And
When is that from?
I'm sorry.
What year?
Just 1 second, Your Honor. That's a 78 case.
Okay, so that one's not relevant at all.
Old case.
Because we have a new evidence code since 78, so, okay.
And Your Honor, even with respect to the older case, the only thing that I was citing Phillips for was the proposition that in the absence of specific legislative or decisional case law on the particular issue that is at hand in Phillips, we commend the Federal Rules of Criminal Procedure, Rule 16, for guidance.
Well, we've got a specific rule here now, don't we?
Well, when you say we have a specific rule, is the court speaking of the discovery statute that says?
That's what we're talking about in this motion, right?
Right, yes, Your Honor. We are talking about that, and the state's position, the state maintained, first of all, let me be real clear, we didn't file a brief. This is the first brief that we have filed where we've asserted these things. We have asked that the court require Mr. Steele to turn this stuff over, but we've never argued it out. Mr. Steele has stood up and said he's not required to, and he has pointed to the discovery statute. The court has said, okay, yeah, he doesn't. And we put that in our motion to the court, that the court has previously made a ruling that we thought deserved a second look at. Defendant Williams has adopted as his witnesses all the state's witnesses in the witness list that he filed. And so, Your Honor, when we assert based on Waddell, and Waddell also speaks about work product, and it makes this distinction between factual history and work product and what the state or is and is not entitled. The state stands on its assertion regarding what the requirements are because of the fact that I understand the court's position that there is no misunderstanding about what case in chief means in Georgia, but as there was this expounding on its meaning in Waddell, I think it's important to recognize that there's not been a similar sort of expounding in Georgia, and we can all presume or take for granted that it just means when the defendant is putting up his particular case. Right.
Okay, so do you have any case law
in Georgia
that supports the position you took in your motion that reciprocal discovery requirements are triggered based on whether you're presenting something as substantive evidence? That's my question to you.
Your Honor, the only what we have in support of the motion is cited in the amendment and in the motion itself. We have not ever presented or represented to the court that there was a Georgia case that addressed this issue, and the conclusion that is asserted in the state's filings are the result of the fact that, one, from our position, it's not addressed directly, that, what case in chief specifically.
So you are telling me that when our discovery statute says that the defendant is to produce or permit inspection and copying of whatever it is that they're in possession or control of, which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at the trial, you think that there's some kind of lack of clarity about what that means? Is that what you're representing to the court?
Your Honor, I'm representing that was the position that was taken. That was what was analyzed in the cases that we have cited in our amended amendment and supplement to our motion to compel. That is, in our position, a reasonable interpretation. And as we've said in our filing, Your Honor, there was the requirement in Waddell that anything that was within the defendant's possession, custody, or control, where the defendant intended to use the item in the defendant's case in chief, that be turned over. The Waddell court, Your Honor, in analyzing the meaning and understanding of case in chief, as the court correctly pointed out earlier, said that if it is going to be used as both impeachment and substantive evidence, that constitutes case in chief. From there, we made the assertion, the state's position, that if the defense intends, because there's nothing in Georgia law that analyzes it at this level, if the defense intends to introduce evidence as both impeachment and substantive evidence, then they have a duty to disclose it. And that is the origin of the state. That is the basis for our position. If you're
right. And have you heard Mr. Steele argue 2 or 3 times before that's not at all what Georgia law means?
We've not made this argument before, so he
I
has
don't
not.
mean in writing. Y'all have not
No,
had
we have
any
literally
discussion whatsoever
What we
in front
have-
of Judge Glanville about.
As I have said
What
in
that
my
means.
motion, Your Honor, what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is stuff that we are entitled. And Mr. Steele has said no, in citing the Georgia statute. He said we do not. I have never asserted, I've never made this distinction. I've never said that case in chief means if it's being presented as impeachment as substantive evidence. I've never made that argument in a written or oral filing.
Okay. All right. Well, I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms.
Your Honor,
Love.
respectfully, I take it very seriously.
Okay. So, anyway, we'll be abiding by the discovery requirements set.
The judge is already talking to you about your candor, because what you want to do is you want to go down and just talk to say anything. And Glanville used to go for it, but this new judge is not going for it. People that's been watching this on Miss Sylvia's channel, everybody else's channel, we all have been saying this for a while. Like, Love goes up there and just talks her way out of a lot of things, but it's like when she's wrong, Judge Glanville never said anything about it. That's why I kept going. So I think that we're going to see a different Love from then on out, or this case is going to get dismissed just off of their wrongdoings. The things that Glanville was letting slide, if Love keeps this up, she's going to ruin this case for the prosecution, and the Wiseman members are going to walk, because what she's doing, this judge is not going for it at all, and that's what I love the most. I'll say what y'all want to say, but I'm telling you right now, this new judge is a good judge. She's a fair judge. She's by the book. She's by the rules. That's how I feel. Let me know what y'all think, man. How do y'all feel about Thug not getting the bond? I'm a little bummed about that, but let me know in the comment section, man. Also, hit that like button and subscribe to the channel, man. It's Eking Up Stupid Opinions. I'm gone.
You couldn't walk a mile up in my shoes. They say that if you snooze, you're gonna lose. Everybody wasting time, but I'm just staying on my grind till I ain't got nothing to prove.